Local adalats are meant to deal with reducing cases by dealing cases out of court, and most of these cases deal with auto accidents, family cases, ordinance violations, and minor criminal matters. Now, Mark Callenter and Jayant Krishnan have written an article recently, which is a strong and scathing critique of the Lok Adalat process. And what they argue is that the assumption that Lok Adalat's necessarily supplement access to justice is not empirically accurate in all cases, since the overall Lok Adalat docket is made up of cases that have already been brought to another forum. And in their article, they say that Lok Adalats do not provide new facilities for the vast portion of potential claims that are discouraged by court fees, the cost of lawyers, the prospects of delay, and paltry recoveries. In fact, they in very strong language, they characterize Lok Adalats as illustrating what they call debased informalism, since it is recommended not by the virtue of an alternate process, but by avoidance of the tenements of the formal institutional process. And I quote, "The Lok Adalat's achievement then is to provide an official process for claimants to secure a portion of their entitlements without the aggravation, extortionate expense, inordinate delay, and tormenting uncertainty of the court process. But the claimant is entitled not to the discounted future value of his claim, but to the full present value. What makes the delivery of the discounted value a benefit is simply that the full entitlement can be vindicated only by recourse to a disastrously flawed judicial system that at best can deliver it in 10 years. Thus, the benefit conferred by the availability of the Lok Adalat is a benefit only by virtue of the enormous transaction costs imposed by the judicial system." Another broad area of concern is the focus that this project has on the inflow of Section 138 Negotiable Instruments Act cases, which basically deal with dishonoring of checks. And the way that they're trying to reduce the inflow of these cases is by actually proposing amendments to an act called the Securitization, Reconstruction of Financial Assets and Enforcement of Security Interests Surface Act, which interestingly is the only substantive changes that they've provided in this entire substantive changes to law. They have not talked about changes to any other law. This is the only law that they've actually proposed amendments in their annexures. And the purpose of this draft law seems to be to improve the use of credit to enterprises which are secured by movable property, and to develop institutions that creditors use for self-enforcement of security interests. Now, Mr. Antoine, who's going to be speaking about banking sector reforms after me, maybe he'll have some more insights into this. But it just seems extremely odd to me that in this entire project, the only substantive change that they're talking about is actually a banking reform change. Now, the next two speakers will actually touch upon other areas of concern in this report. But I'll just look at why this project was shelved at the end, why it didn't take off. Now, one of the reasons, from what I understand from interviewing people, one of the reasons that it did not take off is a tension between the project monitoring committee, which is comprised of 3 Delhi High Court judges, and the steering committee chaired by the Supreme Court judge, because though the relationship between the High Court and District Court is very clear, it's not very clear in terms of constitutionally what the relationship between the High Court and the Supreme Court is. So in terms of there seems to have been some kind of friction between the two bodies. The High Court judges also felt that they did not want foreign consultants, many of whom they perceived as extremely incompetent, coming in and telling them what to do. And also, there seems to have been a sense that they needed to protect themselves from what they perceived as interference from the executive, which is in this case both the central and the state governments. Also, there were 2 parts of this project which dealt with enabling legal empowerment and project management unit, which is basically public awareness campaigns, training of public prosecutors and legal aid, and out-of-court settlements, which dealt mostly with changes to the Surface Act, which were extremely uncomfortable. So what happened at the end of the first 2 phases was that the project monitoring committee said that the project had to go before a full court, and it's not very clear whether the project was blocked at this stage or whether it actually went up to the Ministry of Economic Affairs where it didn't go through. Now, before I end, I, there's a recent book that I want to just flag, which has been released. It's by Arnab Hazra and Vivek Debroy. It's on judicial reforms in India. Now, the interesting thing about this book is that many of the contributors and Mr. Hazra himself, who's a co-author, have worked on this ADB project, and so while if you read the project itself, it may not be very clear in terms of where the political kind of background is coming from. If you read this book, it seems much clearer. So, for instance, Mr. Hazra and Mr. Debroy in this book, they say that legal reforms are recognized as critical to attaining higher growth rates. The importance of the judicial system lies in checking abuses of government power, enforcing property rights, enabling exchanges between private parties, and most importantly, upholding the rule of law. And then they go on to say a balanced, swift, affordable, accessible, and fair justice delivery system, besides promoting law and order, aids in the development of markets, investments, and economic growth, therefore helping in poverty reduction. And I'll end with just a small quote from just referring to Professor Upendra Bakshi's speech, which he made at the Indian Law Institute, ILI, in 2006, where he talks about how judicial globalization further occurs in the name of good governance, which requires an intense reform of justicing under the auspices of governmental and intergovernmental aid and development agencies. He says that in principle, though they are unobjectionable, such auspices often take over the agenda of law reform and the reform of judicial administration and shape them in accordance with their economic and strategic needs. And Mr. Bakshi actually points out how the World Bank and related program Good Governance promote what he calls the structural adjustment of judicial activism. These covertly address as well as overall seek to entrench market-friendly, trade-related reforms of judicial interpretation and governance. Taking a cue from him, it's time we asked how we may deglobalize judicial access to ensure that overseas and national capital do not ride roughshod over the livelihood and dignity of the working classes. How do we prevent the creation of a dual legal system where on the one hand, corporate and government elites have access to proficient courts while most Indians remain trapped in an undercapitalized gridlocked system? I'll just